Someone make it make sense.
I'll read a couple.
Hello, Scroll friends. We are here today for more news out of Ada County. Woohoo! So, a lot going on here. Wild the timing of this defense filing a number of motions, but also a motion for a Franks hearing. Given everything that just finished and went down out of Delphi, we've got another Franks hearing. So we're going to dive into that, and we're going to look at all these court filings and go in order. We've got 13 motions to suppress. We're going to start out, though, with the first filing out of this new batch. And you might think, oh, this doesn't look like such a big deal, but there's a reason we're going over it, because there's a subsequent filing that came in from the judge that responds to this, and it's kind of interesting. So this is the very first one of the bunch. So we've got defendant's motion for leave. So basically what they're saying is this, specifically the discovery motions deadlines of November 14th, 2024. So they're moving the court for leave from the court's order governing like the scheduling here, right? The discovery motions deadlines of November 14th. So November 14th has come and gone. They submitted this on, this is what matters here. So they submitted this on November 13th, right? Their discovery deadline was November 14th. That's going to come up later. Defense counsel and investigators have not, another typo, shouldn't say have not finished a full review of the vast amount of discovery in this case and will continue to do so. Counsel requests that this motion be set for hearing in order to present oral argument, evidence, and or testimony in support thereof. Requested time is 1 hour. So they're requesting essentially two things. One, they're moving the court for leave of the discovery deadline for November 14th. And two, a hearing to present oral argument for, an hour potentially, where they can make their case for not meeting their discovery deadline. And as you can see here, they submitted this on November 13th. Okay, that's the first thing. So again, that will come up again later when we get to the judge's response. So now, next up in line, we have the Franks hearing. Okay. We're going to dive deep into this and what everything means. That's probably too much zoomed in. All right, here we go. Motion for Franks hearing. Moves the court to conduct a Franks hearing. This motion is made pursuant to the 4th Amendment of the United States Constitution and Franks v. Delaware. So, Franks v. Delaware. Let's take a look, because that is where this comes from, Franks hearing, right? We know we've heard a lot about Franks. It comes from Franks v. Delaware. So we're going to take a look at this. Okay. Why is it scroll all the way down? Okay, let's go up. Here we go. All right. So this is from 1978 U.S. Supreme Court case law here. Okay, so prior to petitioner's Delaware state trial on SA charges and in connection with his motion to suppress, and that matters, right? Because we know that there's a bunch of motions to suppress coming our way for Brian Kohberger's defense team as well, on 4th Amendment grounds. So 4th Amendment, that's search and seizure, right? And that's constitutional violation if that's found to be violated. On 4th Amendment grounds, items of clothing and a knife found in search of his apartment. He challenged the truthfulness of certain factual statements made in the police affidavit supporting the warrant to search the apartment and sought to call witnesses to prove the misstatements. So essentially, the grounds of this is, well, let me keep reading, then we'll discuss it more. The trial court sustained the state's objection to such proposed testimony and denied the motion to suppress, and the clothing and knife were admitted as evidence at the ensuing trial at which the petitioner was convicted. So a couple things here, right? So law enforcement had a affidavit, right? Police affidavit to support the warrant to search the apartment. It kind of goes along with like fruit of the poisonous tree. You guys, if you follow trials, I'm sure have heard that, right? So they had a warrant to search the apartment. And in that search, they confiscated items of evidence, such as a knife and clothing, whatever, that were used at the trial. And then he was subsequently convicted. So what this is going to be going to is the grounds of the search, right? Because it's fruit of the poisonous tree. If that search wasn't valid in the first place, then that evidence shouldn't have come in. And then there you go. You have an overturning there of that conviction. So the Delaware Supreme Court affirmed, holding that a defendant under no circumstances may challenge the veracity of a sworn statement used by police to procure a search warrant. So the state was like, no, that's all good. And then that's why this went on to the Supreme Court. Held. Where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally was included by the affiant, in this case that would be the police officer, in the warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause, right, probable cause to search, the Fourth Amendment, as incorporated in the 14th Amendment, requires that a hearing be held, a FRANKS hearing, at the defendant's request. The trial court here therefore erred in refusing to examine the adequacy of petitioner's proffer of misrepresentation in the warrant affidavit. Let's take a look at what else they say here. So to mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. The allegation of deliberate falsehood or of reckless disregard must point out specifically, with supporting reasons, the portion of the warrant affidavit that is claimed to be false. It also must be accompanied by an offer of proof, including affidavits or sworn or otherwise reliable statements of witnesses or a satisfactory explanation of their absence. If these requirements as to allegations and offer of proof are met, and if when material that is subject of the alleged falsity or reckless disregard is set to one side, there remains sufficient content in the warrant affidavit to support a finding of probable cause, no hearing is required. But if the remaining content is insufficient, the defendant is entitled under the 4th and 14th Amendments to a hearing. So what they're saying is, if you've got a portion of false statements in the warrant affidavit, right, knowingly false statements by law enforcement, and there's still other things in there that were a result of the search warrant that were not problematic, that were not false, and all that, then you don't need to worry about it. But if basically the remaining content, once you get rid of all the false statements, right, and as it relates to the probable cause, if the remaining content is insufficient, then we need to have a hearing for it. If after a hearing, a defendant establishes by a preponderance of the evidence that the false statement was, and remember, preponderance of the evidence is the same as greater weight of the evidence, right? So let's just make sure we understand this burden of proof here. That's the lowest burden of proof that we have in the law. So that's where they say a grain of sand plus one, or 50% plus a grain of sand, right? So if you've got two sides that are even, 50%, 50%, it's preponderance of the evidence. It's the same thing as greater weight of the evidence. That standard is 50% plus a grain of sand, basically. So that's the standard of the evidence that the false statement was included in the affidavit by the affiant knowingly and intentionally or with reckless disregard for the truth, and the false statement was necessary to the finding of probable cause. Right. That's the crux of it right there. The false statement was necessary to the finding of probable cause upon which they were then searching, right? Then the search warrant must be voided. And the fruits of the search, there it is. Chelsea, keep reading. Fruits of the poisonous tree, there it is. The fruits of the search excluded from the trial to the same extent as if probable cause was lacking on the face of the affidavit. There it is. So, okay, I think that makes perfect sense. So now let's go back to this document here that we were getting into. So that's what they're asking for. Putting that into the context of this case, what they're alleging then, right? And we'll read more about it. They're alleging that there were false, knowingly and intentionally, or with reckless disregard to the truth, false statements made by law enforcement in terms of them filing their affidavit so that they could have a search warrant, right? So that those false statements got them the search warrant, and then anything that came of that search warrant then is fruit of the poisonous tree. Interesting. All right, so let's see. The parties stipulate to the sealing of the proffered exhibits. A stipulation is filed, so there's nothing else really. So, but that's where all the motions to suppress come in, okay? So what we're going to get to is all these motions to suppress, and what that means is these are all things that they're saying are the result of this invalid, right? Well, if it's deemed to be invalid, right? That's what they're alleging, that the search warrant was therefore invalid. So all the evidence that came of that should be suppressed in the meantime until they have this hearing, if they have the hearing. So, okay, so now we're going to moving right along to the very first of the 13 motions to suppress. All right, first one up, guys. Motion to suppress genetic information. Moves to support all evidence illegally gathered by law enforcement using his genetic information. This motion is made pursuant to the Fourth Amendment and the United States Constitution. This motion is being filed under seal pursuant to Judge's previous order stating that pleadings related to this motion be filed under seal, right, because of the genetic information, right. So basically the only other important thing here, it's saying that they'll deliver this in person no later than November 18th. That's tomorrow. So the rest of the information for this, of course, is under seal. But that's the first thing. So first fruit of the poisonous tree, according to the defense, is the genetic information. So next up, we have Amazon. What do you guys think this is related to? Because if we remember, what did potentially Brian Kohberger buy off Amazon? All right, let's see. This is interesting. So motion to suppress and memorandum in support. Amazon account, federal grand jury subpoenas and warrants dated April 26, 2023 and May 8, 2023. All right. Suppressing all data found by law enforcement from its search of his Amazon.com account. The motion and documents in support of a FRANKS v. Delaware hearing are hereby incorporated into this memorandum. The proffer with supportive documentation regarding FRANKS are filed under seal. So the thing that sucks that I really want to know is I want to know what this is the thing, right? What is it that they contend or allege was the knowingly false statement made by law enforcement in the affidavit for the search warrant? Like, that's what I want to know. However, because that's what they are going to be using in support of this FRANKS hearing, but that's filed under seal. So we'll see what happens. It could be that maybe, oh, glad you're here, need some Z's. Yeah, I know, me too. So it could be that, we'll see what happens. There's going to be, with all these filings, there's going to be a subsequent slew of filings from the prosecution and maybe orders from the judge. They're going to, in other words, what they have that's filed under seal in support of this FRANKS hearing is going to be what the judge will use to determine if he's going to grant that hearing. If he just denies it flat out, we may never learn until maybe after the trial what it was that they are alleging was knowingly false in the affidavit. However, if he does grant them this FRANKS hearing, then the next question will be, is the hearing going to be open to the public, or will it be like under seal? Will it be private? Because if it is open, if they have their if they're granted the hearing and they're going to have oral argument and it is open to the public, then we will learn what they are alleging was knowingly false in the affidavit from law enforcement. I think it was Brett Payne, maybe was the dude, if I recall. All right. So the proffer with supportive documentation regarding FRANKS are filed under seal. For that reason, they are not set forth in full detail here. We'll have to wait, but instead are incorporated. Okay, so we might learn a little bit. All right, issues. 1, Mr. Kohberger has a privacy interest in his Amazon.com account information protected by the Idaho Constitution and the Fourth Amendment. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally admitted material information. So why does this matter? That's the standard. That's what they have to show, right? Based on what we just read from the case law. 3, the affidavit submitted in support of the application for the issued search warrant included information that must be excised. Point A, all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. Okay, that I don't think is going to go very far, in my opinion, because they've argued. If that's all that they're basing this stuff on for their Franks hearing, it's not going to go anywhere, because they've argued about this a lot. There were a lot of hearings about this, especially early on, and it was not found to be unconstitutional. If this is the argument that they are making, and they're saying if what they're saying is like the fruit of the poisonous tree all comes back to the use of this investigative genetic genealogy, I don't think it's not going to go anywhere. I don't think. But let's just see. There could be more, and it could be different for the other motions. I haven't read through these yet, so. And thus nothing in the warrant should remain. Right. And if he denies, if he denies the Frank hearing, then these motions, then it would just be a procedural thing, right? Like if he denies that Frank's hearing, then my interpretation would be that all these motions to suppress, the defense is doing their job. They're doing their due diligence. They're making these, they have to try, right? They have to try. They have to make these, just like with everything regarding the death penalty. They're doing their job, but it would mean that whatever's alleged in these motions isn't really valid, right? So there you go. How did they get to him without the IgG? So that was my recollection of that is, and it feels like a long time ago, was because of the Elantra, because somebody from Washington State University went through and found all the white Elantras or whatever. And if I recall correctly, he volunteered his license or put his license on file somewhere. Like they had that already. Like that's where they got his name, his address, his date of birth, his picture, and all that was like on file with the school. And they connected it to the car. And then that's how they first got to him, was the car, if in my recollection. Oh, I see what you're saying. I mean that it is valid. It would be sus not to have this Franks motion. Right. Okay. So information gathered about Mr. Kohberger via previous invalid warrants must also be excised. Facts. Okay. Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's parents' home on December 30th, 2022, and arrested him. At some point, an FBI agent subpoenaed Amazon records belonging to Mr. Kohberger's account. And there's a footnote 1. Let's see what that says. Footnote 1. Grand jury subpoenas issued by the government have been the subject of a motion to compel. There is an order to compel their production, quote, if available to the state, end quote, or at a minimum for the state to provide dates of subpoenas. Order on defendants' 4th and 5th motions to compel, and I covered those, June 14th. I remember those very well. The state has done neither. So they're saying the state has still not turned over some discovery to them. The issues in the memorandum are among the reasons a copy of the subpoenas are necessary. It is unclear what the subpoena asked for or its scope. The subpoena return identifies 2 iCloud accounts. That's interesting. So without this full information, they're making these motions with still having some of this discovery missing. They're saying the state hasn't turned it over, which is interesting because the state has been saying, I thought things were going better in that direction with them turning stuff over. But apparently they still don't have that from June 14th. Okay. So that was where we saw footnote 1. Where did that go? Right here. Okay. On both December 30th, 2022 and January 27th, 2023, Amazon responded with records showing Mr. Kohberger's purchases. Knife. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the Idaho Constitution on April 26, 2023, Detective Mowry of the Moscow Police requested a warrant for the same information, telling the court that an unnamed FBI special agent had located, and that's in scare quotes, requested information. The warrant was amended due to a date error. I remember that, and ultimately issued May 8th, 2023. The affidavit for the warrant was signed by Detective Mowry, and there's going to be an Exhibit A. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker, but according to Mowry, now the sworn statement of Corporal Payne. So that's when I was trying to remember that guy's name. So I don't remember for sure. Maybe Brett is not the first name, but I feel like it's Brett. But Payne. So that's the statement that we've all seen, and we've looked over it. I don't know that I've actually gone over it in full on this channel because I feel like most people had already seen it, but we've talked about it and referenced portions of it. And I would imagine you guys have all seen this. If you haven't, let me know and we can look at it. Let me take a look and see what you guys are saying in the chat. Well, Law enforcement didn't know about the car when the university documented it. Yeah, it's crazy that they haven't turned that over. That is definitely 2 iCloud accounts, right? Okay, so the basic facts malware used to support the search beyond the arrest warrant facts were very minimal. 1, a vague reference that an FBI special agent located an account for Kohberger. Amazon provided order history records regarding customer email Brian Christopher 1994 at gmail.com. How the agent located this was not explained. So remember, the standard, right, is a statement made by law enforcement in an effort to obtain a search warrant has to be knowingly and intentionally false or with reckless disregard for the truth. That's the standard, okay? So will this meet that criteria? They're saying that there was no explanation as to how they located this order history with this email address. So to me, that's not quite there yet, right? Because it's like missing information, right? It should have been, obviously should have been explained, right? But it's an absence of a statement, whereas the burden, again, for the Franks hearing, according to the case law, is it's not lack of a statement. It's a statement that's knowingly and intentionally false or with reckless disregard for the truth. So, okay. Next, investigators know that Amazon holds records for identifying devices the customers used to access their account, all linked accounts, and other items customers have searched. They left off the ED. Clicked onto, placed into the cart, viewed, and saved. Who or how the investigators know this? I don't know. That doesn't make sense. How the investigators know this is not explained. Again, that's another statement that would be missing. Little information about how Amazon collects and holds data was explained. Again, missing information. This information should be provided, but again, does that meet the standard according to the case law for a Franks hearing? Not quite yet, I don't think. Need some Z's saying, note that the FBI, quote, at some point located, end quote, the account, but then law enforcement, after already knowing about this info, filed their own search warrant for the same info. I'm trying to make sure I understand what you're saying. So they didn't use the information provided by the FBI? Is that what you're saying? I mean, I don't know if I'm missing something here, but one reason why we know, y'all, in a lot of these cases, right? Delphi is another example. We know that there is sometimes a tug of war going on when FBI is involved. Now, we know they only get involved if they have to be invited and asked, right? But it seems like a lot of times law enforcement agencies do this reluctantly, and then there's a turf war going on. I think it's such a shame, right? And then it's like, and we know that this was going, and it seems to be more problematic in these small towns because Delphi had that problem and Moscow PD had that problem where they brought them in and then got rid of them at a certain point pretty quickly, right? And one thing I've pointed out that I want to just reiterate that I think is really, if they don't do anything else right, in Florida, specifically Orange County, one thing I will say is I commend the Orange County Sheriff's Department for doing the opposite. Because as most of you guys probably know, I'm covering the Casey Anthony trial, gavel to gavel, first channel on YouTube to actually cover that trial. Believe it or not, although everyone has an opinion about it, but no one seems to have watched the trial, or at least the whole trial. And no one's watched it and providing commentary and analysis. Anyway, but one thing that they did not have egos about it because they FBI was involved every single step of the way. And I think that's how it should be. If you involve them, right? Like, I don't know why you wouldn't. I guess the only reason you wouldn't is because of the ego turf war thing, right? Because they have all these resources. It just makes sense. Anyway, but my thought too here is in regards to this comment is that potentially because they wanted it to seem like they got the information, if it's like an ego thing, right? They didn't want to be like, we relied on the FBI. Maybe, I don't know. Okay, so number 4 here, this time frame was March 20th, 2022 through March 30th, 2022, and November 1st, 2022 through December 6th, 2022. So those were the time frames that were selected in the Amazon account data. Looks like. All right, argument. That's part of these documents. 1, Mr. Kohberger has a privacy interest in his Amazon.com account information protected by various things. Both the Fourth Amendment and Article 1 protect people's interest in privacy. A person challenging a search. Okay. I actually know quite a bit about this because I've done some studying on this with the Fourth Amendment and search and seizure. So this is interesting. So a person challenging a search has the burden of showing that so the burden is on the person, like the suspect or the defendant, right? They have the burden. That's important to always note, right? They have the burden of showing that he or she had a legitimate expectation of privacy in the item or place searched. This involves a two-part inquiry. 1, did the person have a subjective expectation of privacy in the object of the challenged search? And 2, is society willing to recognize that expectation as reasonable? One thing that I've looked into with this is as it relates to drones being used by law enforcement, where they, they use the drone and they kind of surveil a person's backyard or a person's shed or a person's garage. And what's interesting is that in the cases that I've looked at, times where they've done these searches, and for example, if a person had a shed in the backyard, this is where the subjective expectation of privacy. So one has that in their domicile, and that's the word used in the case law, domicile. And that's like the place in which you reside, right? So a lot of the challenges with this in the case law has been, something like a shed or a separate outbuilding, right? Separate from the home. And that has been held to still meet that standard of a domicile where there is a reasonable expectation of privacy. So for example, if they're just flying a drone over someone's backyard, that is not enough to infringe on the Fourth Amendment right. It has to have this invasion of privacy, such as going inside a building or looking through a window, shit like that. Okay. So did the person have a subjective expectation of privacy in the object of the challenge search, and is society willing to recognize that expectation as reasonable? The Fourth Amendment has generally refused to acknowledge that individuals have a privacy interest in records held by a bank, relying on the third-party doctrine. As this court is no doubt aware, the third-party doctrine holds that information shared with anyone with whom a person does not have a recognized evidentiary privilege is free for the government to take without warrant. To put it another way, the third-party doctrine exists as a matter of law that you should trust your secrets to no one. Idaho has taken a somewhat, interesting. So they cited here Duke Law Journal. That's a really well-known law school in North Carolina, actually. Idaho has taken a somewhat unclear approach to the third, and having said that, I probably even read some of this when I was looking into this a while back about Fourth Amendment search and seizure. Idaho has taken a somewhat unclear approach to the third-party doctrine. In State v. Mubita, the court permitted protected health records to be provided to the government. In State v. Cluss, the court did the same for billing statements from utility company. In State v. Donato, the court held that people had no expectation of privacy if trash placed out for pickup. Now why do you guys think that's going to matter, right? Because we know that they pulled those, they got the way they were able to then get that in terms of the IgG, right? Was the trash placed on the curb. And then I think it was Brian Kohberger's father's DNA was on something in the trash. But having said that, I've always known that to be the case, that once you put trash out on the curb for pickup, it is now belongs to the public. So yes, there is no expectation of privacy there, and that is not a violation if the trash is out on the curb. However, the court also held in State v. Thompson that under the Idaho Constitution, citizens do have a right to privacy in who they call, and later extended that to text messages. Did I say something wrong about Idaho? Did I say something else? The trash pickup is not an issue. It is public. When trash is out on the curb, it is public. That is a fact. And they even cited case law that said that people had no expectation of privacy and trash placed out for pickup. Same way that they got Rex Heuermann in the Lisk case because he ate a pizza or whatever and then put it out in the trash there on the streets of New York City, and then they got the pizza box. There's even a really funny episode. I don't know if anyone of you guys have seen the show Curb Your Enthusiasm. There's a really funny episode where Larry David is taking a walk with one of his friends, and he's brought an apple with him, and he's eating an apple. And he finishes his apple, and he has the core. And I guess it was like trash day. So like all the people had their bins out or whatever. And he's somewhere in the neighborhood, right? And he just goes to like a nearby trash bin that belongs to a residence, but it's out on the curb. And he chucks his apple into it. And they get into some argument over it. It's pretty funny. Anyway, trash wasn't picked up. It doesn't have to be picked up. Once anyone that has a trash bin, right? Like if you're a residential place, like if you're a house, you have trash bins. Once you put your trash in the trash bin, if your trash bins are still on your property, like not pulled out, it's still private. But once you take your trash bins and you roll them out to the curb and they're waiting for pickup, it's public property. And my understanding is they were out on the road, because I remember there was thing about like how he was seen by somebody like wearing gloves to take out the trash or whatever, right? But I remember thinking that the bins were out at the curb, and that's how they were able to do that. Potentially. So you could think of this, you could compare it to an apartment complex. So like at an or a private business, right? So like that's a bit different because it's not on a, so like if you live in an apartment, right? And you've got like a communal dumpster, right? Typically there's going to be signs on that dumpster. And the reason being the dumpster is still on private property, usually, right? They're on the property of the apartment. It's still private property, and that dumpster is not going anywhere. So usually they have signs that say like, private property, no dumping, there's cameras or whatever, shit like that. Same with businesses, but it's the same idea, because the difference being there's a stationary big dumpster on private property. So no one, like, in other words, if you're a random person, you can't put trash there and you can't take trash out. Like, that's the thing. But a gated community where there's separate residences, I don't know. I don't think that would be enough unless there's signs posted saying it's private. But a gated community, in my understanding, is just simply for protection for the people that live there, so that there's, it makes it safer, right? But within that community, the houses are still separate residences. They're private, and then it would be a public. I guess that's the question: is if it counts as a private road or a public road, the street that they live on. If anyone knows or can find the street of his parents' house, we can find that out. If that was a public road or a private road, we can Google Maps it and see, because if it's private, it'll say PBT. If the road's private, whole different story. If the road is public, so if anyone wants to see if they can find that address, we can do some digging on that. Right, private property isn't public, right? But just because there's a neighborhood that's gated, it doesn't necessarily mean the entire thing is private. The roads could still be public. That's why it matters. If we can get the address, we can take a look. Yeah, I'm trying to think gated communities here. I know there's gated communities where the roads are private, and I think there's some where they're not. I think it just depends. So it would be a case by, we would have to take a look and see. So, okay. Idaho is not the only jurisdiction to have trouble with the third-party doctrine. The United States Supreme Court has refused to apply it both to the search of cell phones and the use of cell sites. The issues the United States Supreme Court seems to take with the third-party doctrine in its most recent decision seems to be the scope of information available to the government without a warrant if one follows it closely. The concern was first fully articulated by Justice Sotomayor in her concurrence in U.S. v. Jones from 2012. It is difficult to square this concern with what the court decided in Miller because, as the third-party doctrine's defender, Professor Kerr puts it. And I'm going to take a sip of some water before I keep reading. Okay, in Miller, the checking account created a substitution effect by replacing a transaction that would have included substantial public components with a transaction that would normally occur entirely in private. I'm just making sure I understand that statement. Okay, to see how, imagine a world without banks. If you need to pay for something in this world, you would need to get the money to do it. You would need to travel to your stash, pick up the money, and then travel to the place where you are making your purchase. If you're the seller, you need to receive the money, take it back to your stash, and store it away for safekeeping. There are public parts of the transaction on both sides. Checks and other credit instruments eliminate the need to travel. The buyer no longer needs to bring the money to the seller, and the seller no longer needs to travel to put the money away. Instead, the seller deposits the check and the funds from the bank are sent directly to him. The buyer and seller don't have to move anymore, as the check moves the funds out of and into their accounts without them needing to go anywhere. The third party of the checking account makes the entire economic transition private. Okay. In other words, as Professor Kerr argues, Miller makes public precisely the amount of information Carpenter held private. No doubt the fact that our economy has changed greatly since the 1970s has a part to play in this, but the fact remains that the Miller case and its progeny make little sense in today's world and are irreconcilable with the court's current jurisprudence. In Idaho, on the other hand, the court in Thompson determined with relatively little analysis that Idahoans expected privacy beyond that which the United States Supreme Court held provided for the people they call. Interesting. In essence, the court, without much explanation, held that the dissent in Smith v. Maryland had it right. However, it remains that by adopting the dissent from Smith, the Thompson court adopted a rationale for rejecting the third-party doctrine. From Justice Stewart's dissent, Idaho adopted the notion that what a person does in private does not become public merely by the nature of the act. Interesting. More sweeping is the rationale of Justice Marshall that the court adopted. In my view, whether privacy expectations are legitimate. So first, before I read, this is from United States Supreme Court case law, United States v. White. In my view, whether privacy expectations are legitimate within the meaning of cats, and I feel like I read about cats when I was looking into this Fourth Amendment stuff. Actually, that rings a bell. Depends not on the risks of an individual can be presumed to accept when imparting information to third parties, but on the risks he should be forced to assume in a free and open society. By its terms, the constitutional prohibition of unreasonable searches and seizures assigns to the judiciary some prescriptive responsibility. As Mr. Justice Harlan, who formulated the standard the court applies today, himself recognized, quote, since it is the task of the law to form and project, as well as mirror and reflect, rhymes, we should not merely recite risks without examining the desirability of saddling them upon society, end quote. That's the dissenting opinion. In making this assessment, courts must evaluate the intrinsic character of investigative practices with reference to the basic values underlying the Fourth Amendment. And for those extensive intrusions that significantly jeopardize individual sense of security, more than self-restraint by law enforcement officials is required. Despite this, Donato, however you pronounce that, the court rejected Justice Marshall's dissent. All the same, the court did not simply join the Greenwood majority. Instead, the court took a middle path, set out. So we're getting like the history of Idaho case law and U.S. Supreme Court case law and how they compare and contrast in terms of all of this regarding the Fourth Amendment, basically search and seizure. We're getting a little bit of a background history here. That decision noted distinctions between garbage and telephone calls, in that the latter are open to the public and carry out duties of confidentiality, while the former do not. Again, that is making that same distinction that garbage does not carry a duty of confidentiality, but telephone calls would. As our Supreme Court noted, clearly there's no duty of confidentiality owned by garbage handlers. It's interesting that this is coming up. We're still on this motion to suppress from Amazon, but it's interesting how many times garbage is coming up in this particular motion to suppress the data from Amazon. So there's no duty of confidentiality owned by garbage handlers. Included in that analysis, however, is that Colorado had rejected not only pen registers, but that bank records should be obtainable without a warrant. This brings us to Mobita. The court in Mobita adopted Miller, finding without explanation that nothing in Idaho's jurisprudence would support a divergence. Although the court in Mobita analyzes both Donato and Thompson, the court makes no mention of their rationales and instead differentiates them based on whether there can be a finding that greater protection exists due to the uniqueness of our state. Let me go back and put this in quotes. Greater protection exists due to, quote, the uniqueness of our state, our constitution, and our longstanding jurisprudence, end quote. That's from Idaho case law. Again, it sounds like there's been certain times where Idaho has said, we don't agree with what the U.S. Supreme Court says. We want to do our own thing, which they're allowed to do. That's why we have states, right? Sometimes there's many states that all adopt the same practices. Other times there's, a great example, freaking Indiana, right? They have all kinds of unique things going on there, legal law-wise, that we learn about. And not just me, but also the attorneys who were there in the courtroom had never heard of being done in any other state. So the uniqueness of our state. That's why I wanted to point that out, because that's Idaho is trying to say we're different. This holding ignores the holdings in both cases to craft a new one that should have required the Movida court to reject Miller, given that the, quote, long-standing jurisprudence, end quote, of the only two cases on point in their holdings rejected the simplicity of the third-party doctrine embodied by the Miller holding. Thank you so much, Need Some Z's. Let me take a look. Let's just see. Let's take a look. I'll pull it up here in just a sec for you guys to see. Thank you for that. All right. Lamsden, interesting. Oh, I don't have the right zip code. 18210. Huh. It's not, that's interesting. It's not wanting to come up on Google Maps. Huh. That's, let me share this. So it's not wanting to come up on Google Maps. It makes, so if I do this, right? It's like, oh, there it is. But no, let me pull the comment down real quick. Just so, well, actually, let me just scroll this. So there's the address right there. It's the zip code 18, and it's Effort, Pennsylvania. So wrong city, wrong zip code. So 18210. But if I try to do this, it doesn't take, you know, is that one of those things where they've like figured out a way to block it from being findable on Google Maps? Let me try it a different way. 18. Thank you for finding that, Needs and Z's. Let me just see. So I just did a generic Google search. It's still trying to pull up that other address that's not accurate from what you're saying on here. Okay. I think I found something. Hang on. All right. So this address is accurate. Now it's funny, again, it didn't come up on Google Maps. Interesting. But this, being that this is on realtor.com, should tell us, guess what, if it's on a private, you know, what the deal is, right? Let's just see, because we can learn about the privacy or if it's not for the trash. One story, it looks like it's 2 stories. Oh, I guess that's a basement technically. Weird. So neighborhood. Schools. So they bought it in 2014, his parents, I guess. Yeah. Why would it not have like what you said, if it is part of like an HOA or gated community, why? Okay, maybe we'll get a picture and we can see a street sign, because again, Google Maps is not helping me out here. So it's got a lot of acreage. Yeah, one acre of land, guys. Show us the street. Has a shed. Speaking of sheds. This is wild. I'm surprised it's still on here though. I mean, I guess it's crazy, right? That you can have things blocked in Google like that. I mean, that's the only thing I could think of, because why the heck is it not? Like, it's like it doesn't exist, right? But it exists here. Like, here's the house. So for anyone who's like, what are we looking at? We're looking at, apparently, from what we understand, Brian Kohberger's parents' house in Pennsylvania, using the address from the search warrant. That's a weird looking thing. What the hell is that? Weird thing. It's kind of weird stuff going on. Like, what is this? Now, this could be from the previous people that sold it to the Kohbergers. Maybe this is not what it looks like. You know, this could have been the previous family. They had a strange taste in decor. Oh, wow. That's odd. Look at this, guys. The cushioning on this bar thing. That's weird. Very weird to me. Never seen that before. They collect a lot of knickknacks. Again, this could be the previous family, though. That's so weird looking. Oh, I hate that. Ew. And we're back to the first picture. Gosh darn it. Now it's showing it here. Let's see what happens if I click on this. Is it going to take me to it on the map this way? Oh my God, y'all. Okay. Is this going to be the accurate place, or is it Google Maps going to fail me again? Okay, that worked. Can you guys see that? Look. Oh, it popped up there a second ago. Look. Oh, you guys can't see that. That's weird that you can't see that. It's showing the right address, though, here. Okay. So we're making progress. This is good. So this worked. So it's findable this way. So hang on. This is great. We can take, y'all, we can take it. Yeah, if you got it off the PDF of the search warrant, it should be accurate. Unless, remember the part about the standard for freight, right? Intentionally and knowingly false information. If they put the wrong address on that affidavit, then that could be, you know, I can't imagine they would do that, but that would be grounds for a Franks hearing according to the case law. But okay, but I wouldn't, there's no reason, there's no, I was just saying, like, as an example, but there's no reason to think that. So we can actually see, though, let's see if we can see where the gated community, and where did you learn that, where did you learn it was a gated community? Because the listing didn't have anything about being a gated community, and normally that would be on the description as like a selling point, you know? Where is that? So there's the main road. So to get there, let's just see if we can figure out. Oh, is that a gate? Hang on. A toll road. Interesting. Because in other words, in order to access that neighborhood, I mean, unless that, what is that? Can I go here? Let me see. Can I go here? Can I be a person here? Can I do Street View? Hold on. See, this isn't the genuine Google Maps because the genuine Google Maps didn't have this. It's not letting me, so it's not giving me all the options you want on Google where you can, like, you know, Street View. That's not a gate, though. Like, that's 3 buildings for something. So, but it looks like you would have to, hold on. So the way you would access the neighborhood, right, because the house is all the way over there. So you would have to, see, this does not connect. No, it doesn't connect. Interesting. So you would have to access it via, this is the main road. And then, so in other words, the reason I'm saying that is because if there was a gate, it would be wherever it would be like here, right? Where the, where you turn into the neighborhood. So here's the main road. And then you would have to access it by turning onto here, or wait, nope, not there. You would have to go on this. You'd have to go this way. You have to go this way. So let me just take a look one more time. So again, this is where you would have to access it. So if there's a gate, it should be in this region, I would think. No. I'm looking for a gate, guys. And I'm not seeing anything. But bigger point here is that, hold on. The road, right? Lamsden Drive. Is that road a private road or not? Let's just see. I'm doing a search. Check this out. Check this out. Check this out. Now, this is from AI, but some roads on Lamsden Drive are private while others are public. And their address was 119, right? Where did it go? Yeah, 119. Damn, this is interesting, right? Because some of them are wow. Interesting. So this is really fast because this matters. If it's a private road, that completely changes everything with the trash. Oh, I just realized we just have someone else. Thank you for joining us, Just Beth. I think you've been here before. I'm glad to see you. Gated is from the fans. Okay, thank you. So you said you heard it on someone's video, although it's said in the docs as part of the reasons why. Okay. Okay. Are you saying that's on the listing for the house? Hold on. Didn't I read all this though? Hold on. Where is the I'm not seeing, where do I look for that? Under popular amenities. Okay. Okay. Interesting. So, and I believe that, and we'll see that. But again, I don't think that's enough. It has to be a private road. I would think. Let me just see. This is interesting though. So I'm doing another search. My understanding, like I said earlier, I don't think that automatically they're all private. But I'm going to just look and see because I could be wrong. So typically private. Well, again, having said that, we already know, here's the thing. We know this. So even if it is gated, here's the thing. Even if it is gated, we already know that at least one of these, this is just some of the houses that are just showing up here, but at least one of them is public, right? So even if, so this answers part of the question, that even if it is gated, we do know that there's the potential that their particular road is, their address is on a public road. So that's what we need to find. That's the thing. The gated isn't really enough. You need to know if it's private or public. Wow. What did I search for? Okay. Let me see if I can do this and get more specific information. Oh boy. Y'all, are you seeing this? Row, they might be in trouble. if this is the case, if this is accurate. Holy crap. So this is a different listing, so we could get more information on this one. Because the other one was realtor.com. This is a different. So hold on. Homeowner Association. Okay, let's see if where is it? It came up in the search. Hold on. There it is, right here. There it is. Road responsibility, private maintained road. Well, guys, if this is accurate, this is Redfin. I don't know anything about Redfin. Are they reputable? It looks like it's another competitor to like realtor.com. This is saying it's a private maintained road. Fuck. If that's accurate, this is the problem. This is the big if this is accurate, I don't know how this has even gone forward because that trash is private. Fuck. That's it. I mean, oh dear. How has this not come up? Like, I would have thought that this would have been, if you're his defense attorneys, wouldn't this be like the very first thing you notice? And maybe they didn't notice it. I mean, I would imagine this is like the first thing because like it should be, I mean, fruit of the poisonous tree, right? They got the only way that they were able to get enough to then arrest him via using the was because of the IgG. But again, they had to connect it to his dad. The fact that they got that swab or they swabbed something from the trash. Oh dear. Do y'all remember, did they get anything else from the trash besides whatever they swabbed for the DNA? Was there anything else in the trash of evidence that they took? Or was it just the dad's DNA? Because anything from that trash is done. And anything that's a result of that, like again, through the poison. Fuck. Okay. All right. Let's keep reading. You guys are saying there's more problems. Y'all, I appreciate that you guys, even though some of you guys are already familiar with these documents, you still are wanting to go over it. So we'll keep going. Okay. Fuck. Sorry, it's a lot of cussing, but this is a big deal. So, I need to share this again. I just exited out of my things. Hold on. Sorry. My hand freaked out. Okay. Okay. Wow. Okay. Just the dad. Okay. But still, they used that to connect it to him. I mean, they needed that to then arrest. Because like, so you have two different things. You have your probable cause, right, to like search, right? But then there's the other level that's needed for the arrest. And so that was, remember, guys, that was the thing. The arrest was made literally right after that happened. That was like the last thing. Because remember, everyone was like, what are they waiting for, right? And we didn't even know who it was. It seemed like there was word that they had a suspect, but we didn't know who it was. And then there was, more rumblings. I'm just thinking back then, rumblings about Pennsylvania, but we didn't really know what, maybe. I don't think we knew his name or anything at the time, but it was immediately after they got this trash, right? And then that was it. And then they arrested him and then all that, right? So, okay. So that's, in other words, that's what they needed for the arrest. So in other words, if all this is looking like it is where that was from private property, the arrest goes away. Unless like that's bye-bye. Like you're like, I can't, fuck. Boy, would he get, I mean, imagine that though. Like he wouldn't have even thought, he wouldn't have known that. Like if right, he's being that he's the defendant, right? Let's just say, it's like, imagine like how lucky you would get if you're that person when it's like that road is private. Like, I don't think you would have thought of that in regards to the trash ahead of time. Anyway, okay. Because the other thing, remember, wasn't he also like putting trash in? Oh, wait. Hold on. Hold that thought. Wasn't it also that he put the trash in the neighbor's bin? Because, oh, fuck. Didn't he put the trash in the neighbor's bin? You guys, this is getting way more complicated than I ever anticipated if you think about it. Because I remember hearing that, and it might have been in the documents, again, this is such a long time ago. If he put the trash in the neighbor's bin, A, that would show that he wasn't aware about the trash rules in the private road because he was trying to hide it in a way by putting it in a different bin. However, if the neighbor's trash is on a public road, then we're back to fair game with the trash because it varies by the address, as we saw. It varies by the address. If the neighbor, oh boy, do you guys remember that? Okay. All right, let's keep going. Dear me. All right, instead, the court in Movida looked at a Court of Appeals decision about utility bills. Once again, the court ignored the actual rationale of the holding in Cluss, merely noting that it also applied Miller to billings. In reality, the court in Cluss did no such thing. In Cluss, the court simply adopted the ruling of the district court in the case. That holding, which it adopted, did not simply apply Miller. Instead, the district court had rejected the reasoning of California and Washington cases on the grounds that power usage did not provide any intimate details of Cluss's life. Blah, blah, blah. Okay. This is about HIV status. I don't know that we need to go over all this. Let me just look through here. Again, we're getting a detailed history about how all this has gone down. Thus, although the Movida court held that Miller controlled every aspect of the decision, sorry, let me read that again. Thus, although the Movida court held that Miller controlled, there's a typo in there, it doesn't make sense. Every aspect of the decision belies that holding. Idaho's constitutional exclusionary rule, unlike the federal constitution, protects privacy. Again, they're setting Idaho apart from other places. Given the rationales and the holdings of all the cases, even Movida, Miller has no place in Idaho. Again, this case is not about bank records or purchases from an online company. From the standpoint of the Fourth Amendment, one's behavior at Amazon.com can provide a massive amount of information about a person's private life, such as all this stuff we already know. It's interesting, though, because, I mean, I'm just thinking out loud here. I mean, Amazon records have been used in a lot of cases. So maybe that's why they keep trying to set Idaho apart, right? Because, like, you know, whether it's an Amazon record or like any online shopping, it's it's very similar, right? Tracking, personalization, all that. And that's used in like every case. So like, but I'm wondering if that's why they keep trying to say Idaho's different. We value privacy more than the other states type of thing. So they did not get it from the neighbors. Okay. Oh, man, I'm trying to remember. Y'all, this was such a long time ago. So maybe what it was it that somebody saw him? I mean, we don't even know who this person was. And it's such a vague memory from such a long time ago. It's like somebody maybe saw him putting like where did we learn that there was trash in the neighbor's bin? Do you guys remember? My recollection is that somebody like saw him putting trash in the other bin or something like that. But I guess that could still be true. But that it could also be true that there was trash in their own bin that his dad took out, and thus the dad's DNA, right? Because that does matter. Okay. I'm not going to read all this. This is just about how Amazon has so much information about us. Given the sheer amount of information Amazon retains, the Fourth Amendment, as understood in Carpenter, requires a warrant before the government can access such information. So they're saying they got the information from Amazon without a warrant, it would seem. And as for Idaho, right, like I said, Idaho special, there can be no doubt that Article 1, Section 17 requires a warrant before law enforcement can access Idahoans' online records. Amazon.com, like phone companies, is heavily regulated and guarantees its customers' privacy. It is not garbage one leaves, again with the garbage, that one leaves on the street where Snoops can find it, nor is it HIV information that society has a stake in knowing. For these reasons, the court should find that a warrant is required to access such information. Thus, the FBI's subpoena gathering the information from Mr. Kohberger's account violated his rights, and its results must be suppressed. All right. Again, they're echoing the standard like we looked at earlier from the FRANKS, the OG FRANKS case. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally. Oh, keep reading, Chelsea. It says omitted. Not good enough, according to what we read. Omitting, I don't think counts given what we read. Now, I didn't read the entire opinion, but we looked at the summary and the holdings, and they clearly lined out the standard, and I don't know that omitted will count. We shall see. The Fourth Amendment states unambiguously that, quote, no warrants shall issue but upon probable cause supported by oath of information and particularly describing the place to be searched and the person or things to be seized. Probable cause exists. Here we go. Probable cause exists when, given all the circumstances set forth in the affidavit, quote, there is a fair probability that contraband or evidence of a crime will be found in a particular place, end quote. Now they highlighted that, right? Emphasis added. Us trial watchers and court document readers know that's a big deal when they do that. Quote, for a search warrant to be valid, the judge issuing the search warrant or issuing the warrant must rely on an affidavit or affidavits sworn to before the judge or by testimony under oath and recorded that establish the grounds for issuing the warrant. And that also was mentioned in the FRANKS case law. Okay, so that was the FBI that claimed they saw that when they were like doing a stakeout. Dun, 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 dun. Anyway, okay, so that if that's what you're saying, that does ring a bell. Okay. It was before. Because they needed it in order, again, there's different standards, right? You got your standards in order to search, and then you have the additional, right, further information and standards that need to be proven with affidavits, right, in order to then make an arrest. So, and then further, the next step then is charging. That's another one. So like 3 layers, right? You've got like, search, right? Search warrant. Then you've got the next layer, that, higher standard is to arrest. And then further than that, you need further things to charge, either an information or an indictment from a grand jury. So in other words, the IGG was the thing they were waiting on to come back from the dad before they could make an arrest. They didn't have enough for an arrest. And remember, they didn't have the information about the DNA on the knife sheath yet. The DNA on the knife sheath was used for charging, if I recall correctly. But for the arrest, the IGG and connecting it to the dad was that's my recollection of it. Because they were waiting on that. And it was like, as soon as they had that, then it was, if I remember, it was something like, we learned about it 3 days later, but it was like actually the next day after they got that they arrested him. Okay, so, right. So we just read that part. Quote, any discrepancy between the items for which there was probable cause and their description in the search warrant requires suppression, end quote. It is clear that the issuing magistrate himself, if he is to fulfill the constitutionally mandated function of interposing independent intelligence between the law enforcement officer and the citizen, must actually and in fact draw the inferences from the evidence presented to him. It is for this reason that the courts have insisted that full facts from which inferences might be drawn and information necessary to determine their reliability be placed before the issuing magistrate. Finally, a criminal defendant may challenge. Right, and we read this, right? And if they do so, they have the burden. But we read this in the FRANKS case law. Finally, a criminal defendant may challenge the veracity of an affidavit used to obtain a search warrant. Now, I wonder if there is any time limit set to that. I'm sure we will see if there is. It would make sense that it needs to be done sooner rather than later, right? Because, of course, like, fruit of the poisonous tree, right? All these other things are going to happen potentially after the search warrant, possible arrest, and then possibly being charged with a crime. Okay, upon a preliminary showing of a warrant's deficiency, the defendant must prove, right, and we covered this, that's the burden, preponderance of the evidence, right? That's the same as greater weight, that's 50% plus a grain of sand. That's the burden on the defendant, the defendant, that they have a preponderance of the evidence. Quote, that intentional or reckless falsehoods were included. This is why I keep saying omitted, I don't think is enough. And even what they're citing in their own motion here, they're saying included, and that matches what we saw in the case law. Included, keep that in your minds, guys. Intentional or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately okay, I take it back. Keep reading. Now we see the word omitted. Okay, that's different then. That's different. Now we have omitted. Now that was not included in the FRANKS, but that is here from Idaho case law, from the Idaho appellate courts. Quote, an omission of exculpatory facts is material only if there is a substantial probability that had the omitted information been presented, it would have altered the magistrate's determination of probable cause, end quote. And that makes sense because we know that this is the case with like literally everything else, but this is very specific as it pertains to probable cause for a search. Quote, whether an omission was intentional or reckless might be inferred in part from the relative importance of the information and its exculpatory power, end quote, again, citing Idaho appellate courts. In this case, law enforcement either intentionally or recklessly omitted exculpatory evidence as to almost every facet of its affidavit for this warrant. Thus, it will require suppression. The proffer required for a Franks hearing is filed contemporaneously under seal. The proffer asserted applies here. In addition to the proffer, the affidavit for the Amazon search warrant did not explain to the magistrate that federal agents have been talking to Amazon and issuing subpoenas, and that was how they gathered information for the affidavit. So they're saying this was left out of the affidavit, right? And that's one of the things that they didn't cite in the affidavit where they learned that information, but they learned it from the FBI. Mallory intentionally failed to disclose the illegal means by which investigators had located the Amazon information. Here's my read on this, because again, it's not illegal, like the FBI, like that's legitimate, right? Here's what I think this comes down to. And this is, there was a comment I pulled up earlier from Need Some Z's about this. And I was like, trying to figure out, I was like, I can't imagine why that would be a problem unless it was a turf war thing. But now, given that we've read on and we've seen what the Idaho case law says, and that they are trying to set themselves apart from US Supreme Court case law, now I have a different take on that. Let me see if I can find that same comment so I can pull that back up and show what we've learned thus far here. So as to why they would do that, I guess it could still be a turf war thing. But what I was thinking about is that the problem with them doing that could be, and the reason why they are saying it's illegal means, right? Because, I mean, the FBI, like, it's not illegal. Like, you know what I mean? I think what they mean is that it's illegal by Idaho standards, because according to the US Supreme Court, and therefore it would be the FBI, that's fine. But by Idaho standards, right? This is my take on this. By Idaho standards, what applies to the US as a whole doesn't also apply to them when it comes to search and seizure, because they value their privacy extra. So therefore, if they utilized what was given to them from the FBI, it's still infringed upon Idaho, the rights of Idahoans, as they have said. That's what I'm thinking is going on here. Yeah, and thanks. Glad you're here. I think I've seen you before as well, and welcome. Glad you're here. And the way you say rubbish makes me think you're in the UK, which if you are, awesome. If you're not, also awesome. Wherever you are, cool. Yeah, I mean, at the same time, though, it's like you'd have to, you couldn't get rid of all, you know what I mean? Like, even if you were some sort of genius mastermind, it would be, the thing is it's just tough in this day and age, right? Because because of the technology. Like, assuming, again, if the trash is fair game, right? That's still up in the air at this juncture. But, you know, how easy it is to leave DNA behind. And then with all the you know, IgG and stuff, it seems like it would be really hard to get away with a crime, I would think, you know? So, okay. The affidavit, so here we are, Roman numeral 3. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. Where information in a warrant was obtained via a violation of the Constitution, Idaho courts excise, again, going back to here's how we do it in Idaho, Idaho courts excise that information. Now, the one thing I will say is that in terms of mandatory binding authority, this is where it gets tricky, because technically speaking, U.S. Supreme Court case law is mandatory binding authority. I think that where it might be different is when you've got things that have to do with the Idaho Constitution. If it's something that is a protected right via the state constitution, therefore, if that is something different from Supreme Court case law, then in other words, the Idaho case law would be the binding authority. Idaho Supreme Court case law. I really hope they have this hearing and argue this, because I want to know, like, this is so fascinating to me. There's a lot of issues, like just legally speaking, right? Like going on here that I'm not even saying all of the things that I'm thinking, because there's like, I'm thinking of like so many different layers to this, but anyway, all right, let's keep reading. So all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy. I'm just going to say IgG because it's just easier. and thus nothing in the warrant should remain. I want to know what they're going to do with this trash thing. Anyway, Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he argues that there would be no investigation into him without that original constitutional violation. That, it seems, I agree. I think it's true that there would not have been an investigation. Like they needed that. From my recollection, they needed that in order to make the arrest. It is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, right? A person whose only connection to the case was his mode of transportation. That's what I said. So I think it was Needs and Z's was asking, how was it that they first came, he was first connected to the case? And I was like, well, my memory is because of the car. So that's what it's saying here. His only connection to the case was the mode of transportation. And the shape of his eyebrows. I don't know how far that went. I think it was more about the car. Two identifications of little to no value, as the Idaho Supreme Court has explained. While the initial burden showing a factual nexus between the illegality and the evidence, the state must show it would have been discovered anyway. Okay, that's interesting. The state must show it would have been discovered anyway. I could see them very easily making the argument that it would not have been discovered anyway without the trash. The state cannot make this showing. Without IGG, there is no case. Yeah, I agree with that. 100% agree with that. They would never have been able to connect it to him. No request for his phone records, right? Because again, fruit of the poisonous tree, they're saying these are all the things that came subsequent to them using IGG to then identify him. So that would be request for phone records, surveillance of the parents' home, no DNA taken from the garbage on his driveway. Oh, there it is in the gated community. Okay. Under a garbage collection ordinance. Okay. Okay. Hold on. I'm looking it up. So apparently these ordinances vary by the state. Okay. What did it say specifically? Garbage collection ordinance in a gated community. Let me do this. Oh, it's done by the borough? Well, fuck, I don't know what borough he's in or his family. What was the city again? Albert something. Let's see if we can figure out what township they're in. Albrightsville. Okay. It's in both Kidder and Penn Forest townships. Interesting. It's an unincorporated community. Huh. Kidder and Penn Forest townships. Okay. So I don't know that I'm not going too far. That I find all the freaking specific. I don't know that I need to do all this. So here's the thing that's interesting. Here's the thing that's interesting. What's interesting is that what they haven't said yet, and maybe this is an upcoming document. What they haven't said yet is that the trash was private. Think about that, right? That's the thing that's missing. So they're saying they are saying it's in a gated community under a garbage collection ordinance. But what they didn't follow that with is something like, and therefore it was still private property. So we shall see. We shall see. Because the IGG analysis is the origin of this matter, everything in the affidavit should be excised. Information gathered about Mr. Kohberger via previous invalid warrants must also be excised. There's the conclusion. Okay, let's go on to the next ones and see what else we have here. So, the arrest warrant. Wow, this is interesting. Okay. Oh, I should have shared the tab before I clicked out of it. Hold on, sorry guys. Right. So that's the thing. The thing that I'm waiting for them, though, is for them to make that argument. That's the thing that's interesting. They're not quite saying that yet. Like the part where I jumped to, like, holy shit, like, if it's private, this whole thing is fucked. They haven't added that last bit yet of therefore the trash is private. So we'll see. Okay. Did I mean to click on this one? Yeah, I did. I'm going in order. In terms of the docket. So here's for the apartment. All right. Motion to suppress. Well, there's his apartment address. In case we didn't have that before. There it is. And see, a lot of this is going to be the same, like, copy and pasted from the previous ones. So I'm not going to read it again. But again, it's under seal, a lot of it from the Franks. Okay. Issues. The court should apply Idaho's. Actually, you know what? I'm not going to read the issues ahead of time because they are going to come up later in the document when they go through it one by one. So, all right. Facts. Due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following are the facts relating to obtaining the search warrant for his apartment. On December 28th, Trooper Larry of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger. So again, objective of arresting. So they didn't have enough to arrest him yet, right? On December 29th, a magistrate in Pennsylvania issued a search warrant for his person. Okay. December 29th, the magistrate in this matter signed an arrest warrant. Wait. I remember this coming up. Do you guys remember this coming up? The timing. Because here, fuck. Okay, so 145 PDT. I don't even know what that means. Pacific? I don't know why would. Anyway, right. Okay, because right. Okay. What matters is looking at these. So 145 PDT issued a search warrant, and at 222 PDT signed an arrest. I remember hearing about this. That's sus, because that is only 15 minutes plus 22 minutes is 37 minutes, right? 37 minutes. 37 minutes, guys. 37 minutes. They went from signing the arrest warrant to signing a search warrant or issuing a search warrant to signing the arrest warrant. Yeah, that's not good. Oh, I was right when I said Brett Payne. Okay, cool. The basic facts used to support the search warrant. 1, next to the body of Madison Mogan was a tan leather knife sheath. The lab leader located a single source of male DNA. Again, they didn't know that belonged to him at the time, so I don't really know why that would be enough to connect it to him, unless they mentioned the Amazon purchase. Footage from King Road neighborhood showed the vehicle. Right, this is all stuff that we're aware of with the vehicle. And then, of course, Dylan Mortensen, recognizing him, or whatever, she saw somebody. Again, more about the car. Okay, here's the part I was mentioning. So it also showed, records from a traffic stop, right? It also showed he had the phone number 509, whatever. He noted investigators learned this was an AT&T number. Right. So remember when I was trying to remember earlier about how they got, like, his personal phone number? He gave it to them at a traffic stop. That's what it was. Right. Now I remember. Now it's all coming back to me. Right. This case has been going on for a long time. He gave, and that was in 2022. I think we've seen that. There's the body cam footage that he gave his phone number. Right. I remember that. Okay. Mr. Kohberger had changed his vehicle registration. Blah, blah. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the murders. This is so silly. In law enforcement's experience, however, people committing crimes typically turn off their phones. Yeah, but see, like that, you can't. I mean, if somebody tried to say that in trial, imagine the objection, the mistrial. Like, you couldn't say that. The jury can glean that, but you can't say that. Historical cell site information. Like, again, the jury, the jury could determine that using common sense, I guess is what I was going to say, but you couldn't, like, say that. That's like, invading the province of the jury. Historical cell site information was obtained and given to the CAS team with the FBI. The team determined that on November 13th at 2:42 a.m., His phone was utilizing cellular resources that provide coverage to the apartment in Pullman. They support the idea that he left his apartment and went south. They support the phone being off. They support at 4:48 a.m. that the phone is south of Moscow. The phone utilizes resources that make their way back to Pullman. This is all stuff that we've already heard about, seen. Right. The same team determined that Mr. Kohberger had been in Moscow on at least 12 occasions and prior to the event, and then came into the area following the morning following. Again, this is all review. However, law enforcement without explanation indicated it did not believe that final trip ever occurred. What? I don't understand what that means. What does that mean? So again, when they're referring to the same team, that's the CAST team, right? FBI CAST team. Are they saying that they said the phone was there 12 times before and then into the area the morning following, but then they changed their mind? Because if so, that's news to me. I had not heard that before. Is that what they're saying? Why? This doesn't make sense. That's interesting. So if this is meaning what this seems weirdly stated, but if this is meaning what I think it's meaning, what they're saying is that somehow his phone showed up there, but law enforcement thinks he wasn't there, as in there's some problem happening, right? Like if they don't believe the final trip ever occurred, but yet this CAST data is showing the phone was there, but they don't think he was, what's like, huh? So that this is like instead they're saying what they are saying is not what they're saying. That's too many layers of who's saying what. I'm not sure, but that is funny. Right. The vehicle registration is not sus. No, I agree. I don't think anyone thinks it's sus. I think that was only included just to show like how they were, because they have to show that it's still the same person's car, right? I think that's the only reason that's included. I don't think it was meant to be. I understand. I remember when this came out, and I remember, of course, the general public, not like I care what they, I remember people all being like, oh, that's sus, right? That doesn't make any sense to me. And I don't think that's what law enforcement included it for. I think it was just to show ownership or possession of the vehicle, that's the same one or something like that. Right. I understand that the cell tower right. I understand that part, but the thing is that, well, we won't know this until the trial. The thing is that they would have to have some way to make the distinction then, right? That the 12 times before the event, they could determine he was there. And that's going to come from the cell data, which we don't have, based on which tower and what side of the tower it's pinging. And then that would make sense then that the 12 times before potentially it did ping and it's accurate that it's actually there, right? Versus maybe on that last trip, it was using that tower, but didn't, it was on the different side or whatever they call it. I'm trying to remember the actual word for that. But they have like the triangle that they do, and it can ping from the different sides and all that. And it doesn't just go to the closest one. I remember learning that from Murdoch. The pinging is not based on that. It's like, I remember actually, like, even with reviewing all the stuff with Murdoch, like there were times where like one of the Murdoch family members was at their house, like on Moselle Road, and it would be pinging at towers over near Varnville, even though there's towers that are way closer, and those towers are super far away in comparison. And they explained how all that works, and it's I'm not a saw expert, so okay. At 2:43 p.m., a criminal complaint and probable cause order was filed in the matter. At 10 o'clock, Pennsylvania SWAT made preparations to arrest. Despite days of FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. And despite the fact that the constant FBI surveillance showed Mr. Kohberger was unarmed, intended to go for runs around his parents' neighborhood. Interesting that they're including that part, right, about the going for runs, because of the whole thing with the alibi. Police decided that in the dead of night, within his parents' home, was the way to make their arrest. That's how they do it in the movies. Okay, now we have the warrant for the apartment, right? Okay. The affidavit shows that Sergeant Blaker of the Moscow Police Department requested the assistance of the WSU Police Department in investigating this case. The affidavit relied on the same information outlined above. They invaded the home and arrested him. Okay. Argument 1, the court should apply Idaho's exclusionary rule and law to this search. This is a good point, right? Like I said, this is where it gets interesting. Whether Idaho law or Washington laws control the validity of the search warrant. Again, that does matter because Idaho is setting itself apart when it comes to that, and Washington might not. So that does make a difference. Unlike the issue of arrest warrants, cases involving multi-state investigations have produced far less case law. Yeah. In fact, the defense could not find a precise case on point for the state of Idaho. Interesting. The issue, however, has received some attention in academia. Professor Kerr argued in his article for the Harvard Law Review that the jurisdiction where the crime occurred should control how the investigation is done, but that states and our federal government should provide some form of authorization to each other to participate in each other's criminal investigations. As it stands, there are at least 5 different approaches to this increasingly common situation. Fortunately for this court, Idaho and Washington, there you go. Idaho and Washington do not differ. So Washington stands alone with Idaho, or Idaho stands alone with Washington. Do not differ in their approaches to the enforcement of their 14th Amendment analog provisions. Both do not accept the good faith exception. Thus, this court can likely afford to leave. Okay, so that gets rid of that problem. The court can likely afford to leave an open-ended question which form's exclusionary rule applies. However, it is also clear from the grounding of the exclusionary rule that evidence obtained in violation of the Constitution must be excluded. Thus, Mr. Kohberger argues that the Idaho Constitution's exclusionary rule must apply, as its basis lies not only in deterring public misconduct, but because exclusion is constitutionally mandated and judicial integrity demands it. It is not at all clear whether a search should be judged by Idaho's standards of reasonableness or that of Washington, or in the case of the FBI agents, by the Fourth Amendment. Yeah, different standards. That matters. I'm going to just highlight that because that matters right here. That's important. Thus, this court should be required to apply Idaho search and seizure laws to their actions in Washington. However, this concept has its detractors. So, you have to do this. If you're going to write a complete motion, you have to present the unfavorable, supporting evidence, such as, case law or, whether it's an authoritative or a source or a non-authoritative source. So this is what they're doing. They're going and presenting the unfavorable information here. So McGlynn argues that when the CITES officer is performing search, they should only be held to upholding their own laws. While that position has merit, as it does not require a CITES officer to get a rundown of the differences between their law and the trial states' laws, it remains that the Idaho Constitution is not merely concerned with deterrence to officers who misbehave. Moreover, it is of concern, they left off the O, that such a rule would permit forum shopping. Yeah, that makes sense. After all, if Idaho's law enforcement may take advantage of laxer restrictions in a different state, they may simply pause their investigation until their suspect is in that new jurisdiction. Well, they would have to know that he was going to go there ahead of time, he or she. Or in the case of the FBI, state law enforcement could at any point, even within Idaho, call upon federal agents with the far laxer rules of the Fourth Amendment. Ooh, yeah, I see where they're going with that. Finally, it must be said that there's very little daylight between the Idaho Constitution and Washington Constitution. If anything, Washington appears to have stricter requirements for probable cause. Okay. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. So again, that's meeting that standard as outlined. And a lot of this is still, again, copied and pasted from the initial one outlining probable cause. So I'm going to skip to where it's specific to this particular motion. Again, this is all exactly the same. They copied and pasted all this. Yep. We read all this. Right? The issuing magistrate, we read that. This is all the same. And that makes sense because the title for the Roman numeral was the same as in the other document. Yeah, this is all the same. This is all the same because remember we talked about this is the Idaho appellate law. Yep. Okay, Idaho appellate case law. And I wonder if this is all going to be the same. Again, because fruits of the poisonous tree, right? So that would make sense that they have the first thing and then everything else that came of it, the argument would be the same. Once you get into excluding it, especially if it's all from the same thing, like the IgG, it's all a result of that initial IgG. Pen trap. What's a pen trap? What is a pen trap? Now this part's different. That wasn't in the other ones. Separately, the information gathered via the warrant for Mr. Kohberger's AT&T account and the pen trap and trace device warrant should be excised for reasons set out in those warrants. Now, I did see that there is a motion that has those words in it, so maybe we will learn what the heck that is, a pen trap. Okay, so next up. This is for Apple account. iCloud. Okay. Again, this is all the same. And we know that there was mention of more than one iCloud account. So, and again, this is all the same. This is the same. So the outline for the argument is the same. It's just that there's going to be certain facts that are different depending on what is in the particular motion. Like this would be specific. Okay. So the FBI issued a preservation request letter to Apple. He arrived at the house and arrested him. An iPad was located at the parent's home, but it was not seized because it was found in a common area. During a subsequent search of Mr. Kohberger's vehicle, a receipt was located for an Apple iPad. Oh, based on incomplete records available to the defense, FBI served a grand jury subpoena on Apple, and Apple produced responsive data for these two different Apple accounts. The data was shared with Corporal Payne. Subsequently, Apple sent an email to an FBI tactical specialist acknowledging the receipt. Okay, the communications reference, quote, setting up a chat, end quote, with Apple's point of contact to discuss issues that need to be clarified or resolved. The communications also include Apple telling law enforcement which accounts do or don't exist for Mr. Kohberger. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the United States and Idaho constitutions. So I see where, again, remember just a few minutes ago, and I was like, I see where they're going with this. Here's an example that you can use, interesting. So you can use the FBI to get around some of the Idaho specific rules as it pertains to searching. If you involve the FBI, then that would explain why they got them involved and they promptly dismissed them, right? Interesting. Wow. Because again, they have the Laxer rules for that, as was mentioned in the previous document. Wow. Interesting. So that's exactly where I thought they were going with it. And again, this footnote here, just to point this out, is we saw this in the first motion that we read. So this is exactly the same thing, but it's just to reiterate, they still have information missing from the state that they have not turned over as it pertains to these two iCloud accounts. The defendant's fourth and fifth motions to compel. Wow. Wow. It's a good thing this trial got pushed out. Jesus. So Corporal Payne served a subpoena later that day via email. On August 7th, 2023, Apple sent an email to Corporal Payne responding to the warrant and providing access to responsive data. downloaded the data from the search warrant from Apple. And then this was the affidavit was signed by Payne. However, most of the information in the warrant was cut and pasted. Right, we saw this earlier as well. They've mentioned this before. Cut and pasted from the which is interesting, right? That it was cut and pasted using mostly the same information, and changing the name. That's a problem too, because it's a sworn statement of Corporal Payne, but it wasn't really his statement because the majority of it was cut and pasted from a. And before, when we saw this, it was a different sergeant. Like Corporal Payne apparently has like copied and pasted multiple other people's statements and put them into his own. That seems like a problem. Wow. The basic facts Payne used to support the search beyond those included in the arrest affidavit were: 1, his knowledge of Apple and what data it maintains within an Apple ID; 2, the method that iCloud uses to create, store, access, share, and synchronize data; that Apple had responded to the federal grand jury subpoena; that a full iCloud account under the name Brian Kohberger was in active status, and another account, wifiarmyowns. What? That's weird. At yahoo.com was inactive. What the fuck is that? What the fuck is that? That's weird. Huh. Using the information produced in the federal grand jury subpoena, Corporal Payne determined that the AMS subscriber account was linked to this email address. That looks, Northampton, is that a school? Did he go to a school called that? I don't remember learning that. Timing of account access is searched by Corporal Payne was around December 20th, when Payne knew Kohberger was in Pennsylvania, still accessing the Apple account with a known iCloud before the homicides and then days before his arrest. Wait, timing of account access. Oh, okay. So he started searching from December 20th. When he knew he was in Pennsylvania. I think I could see where this is going too, because now you're gonna have Pennsylvania issues, right? Because the fact that he's in Pennsylvania, right? Like they were talking about before, like Idaho and Washington kind of agree when it comes to the rules for searching, but Pennsylvania could be different. It's gonna get more complicated if he's in Pennsylvania using the Apple ID, right? Maybe. Corporal Payne requested a very broad time frame. And again, this is some of the same type of thing we've seen. He has a right, requiring a warrant. And we read, this is all the same as before. We read this. Okay, now here's what's different. Here at stake is data collected by Apple Incorporated through Apple accounts and or iCloud accounts associated with Mr. Kohberger. The records the state sought included: 1, all records or other information regarding the identification of the account, to include identifying information about the account owner, information regarding the devices, the contents of all emails, the contents of all instant messages, the contents of all files and other records, all activity, blah, blah, all records and information regarding locations where the accounts were accessed, all records pertaining to the types of service used, all files, keys, or other information necessary to decrypt. That's supposed to say any, not and. Any data produced in an encrypted form. And again, this is the same. This was in the first one. Okay. In this matter, Corporal Payne specified in his request for that purpose. That the purpose for gathering the information from Apple was a belief that the Apple accounts would provide information concerning Kohberger's plans, thought process, research, locations, photos, or other. Yeah. I don't like that. As if it's it sounds like what he was trying to say is, here's why it's relevant, because he's going to have a murder to-do list typed up and saved on his account, as if people would do that, right? The third-party doctrine again. Therefore, to collect the records law enforcement requested from Apple, it had to have a valid warrant, and that valid warrant could not rely on a records produced by a federal grand jury subpoena or a search warrant that recklessly omitted and intentionally omitted material facts. So they got two different things going on here. They've got the problem with the facts. That's like the FRANKS hearing, right? The FRANKS motion for a FRANKS hearing. But then they have the other thing, which is like the issues with the searches being jurisdictionally speaking, right? Idaho versus Washington versus Pennsylvania versus the entire country and all the different standards. So it's like two separate and simultaneous things that they are addressing, from what I can tell so far. This is a lot of the same. Okay. Apple ID. Oh, are you asking about, was that about the Army thing? Yeah, I have no idea. That was a very weird. That Army thing was like I don't think it's implausible to me that any person would actually make that as their username, right? Like that doesn't seem like a legitimate, that seems like a bot or something, right? Like that didn't make sense as like rings true as a person's, like, versus seeing somebody's name and year of birth or whatever, it just doesn't, that doesn't seem legitimate to me at all. Right. Of course. Right. No, they're all connected. But again, just in terms of for the Franks, there's specific things that have to be met for the Franks hearing, right? And like, for example, even if they don't meet that standard and the judge denies it, they still have these other issues with the search and seizure. In my view. Okay, so this is all about the iCloud keychain. As for Idaho, again, special, there can be no doubt that article, can you guys see my mouse? I don't know why you can't see my mouse. That article in section 17 requires a warrant before law enforcement can access Idahoans' online records. Apple Incorporated is heavily regulated and guarantees the customer's privacy. Again, Idaho's constitutional exclusionary rule protects privacy. And again, a lot of this is the same again. Yeah, this is all the same, taken straight out of the first one. And mentioning the IGG again. Yep, that's the same argument. Sped up the investigation. This is exactly verbatim as it was in the first motion. This is specific to the Apple. So the warrant in this matter fails to actually provide a command to search for a particular Apple account or the contents of the iCloud. It orders seizure and has no time frame. The dates in Corporal Payne's affidavit never made it into the warrant, and the affidavit was not incorporated into the warrant. Instead, the warrant said generally, 1, there are grounds for issuing a search warrant. 2, there are grounds to believe the property referred to and sought in or upon said premises consists of information related to investigation of crimes on the Apple account of ... The command is made to search the premises for the property and seize it. The premises is 1 Apple Parkway. There is no incorporating language for the search warrant affidavit. There is no time frame. It says all for every paragraph. Paragraphs A through I have much broader and extensive language than the affidavit. And now here's some more Idaho Supreme Court case law. That the U.S. Constitution requires that warrants must particularly describe the place to be searched. Right, that's already come up. However, decisions must reflect the recognition that the Fourth Amendment's commands, like all constitutional requirements, are practical and not abstract. The Supreme Court has acknowledged that a court may construe a warrant with reference to a supporting application or affidavit if the warrant uses appropriate words of incorporation and if the supporting document accompanies the warrant. So I see what this is really, this is smart, right? Because what they're saying is, yes, this would be, adverse case law if in fact those things had been done, but these things haven't been done in this case, is what I think they would say. Oral argument, right? That because they already outlined before, it didn't incorporate the appropriate words, and it didn't provide supporting documentation. In this case, however, there's no reference to affidavit, only to proof, in quotes, scare quotes. The word proof does not specify that the court relied. This is supposed to say what. The word proof does not specify what the court relied on the affidavit for its probable cause determination. Additionally, there's no evidence that the warrants and affidavits were attached to each other, thus the warrants do not permit. Again, the supporting documentation. They're saying there's no evidence that they were attached. So that again, back to this one, right? You have to have the supporting documents, and they're saying they didn't. The search warrants failed to provide specific particularization of what to search. And they've already mentioned that a bit. In striking a balance between law enforcement interests and the rights of individuals to be free of unreasonable searches and seizures, the process of segregating electronic data that is sizable in form, that which is to just not become a vehicle for the government to gain access to data that it has not probable cause to collect. There must be some threshold showing the government may seize the haystack to look for the needle. That's a really succinct way to put it, right? I'm going to say that again. There must be some threshold showing before the government may, quote, seize the haystack to look for the needle, unquote. Right. The data compilation requested in the Apple warrant is too broad in that it makes no attempt at narrowing. So back to the narrowing. Any of you guys who were there for all the coverage I've done of the death penalty motions, it's just funny because the narrowing is a huge deal for that as well. It's just interesting. It's the same idea. You have to narrow the pool. And it's interesting that that's also coming up here. And results instead in a blanket request for everything available in 2 Apple accounts with iCloud, which is akin to the search of all electronic records, entire computer, or all data on a cell phone. It is a request for the full haystack without any temporal restrictions. Jurisdictions across the nation agree that such broad warrants are problematic, but found that trying to fix the issue via more particularized warrants has its own issues. Still, this case presents a warrant that is overbroad under the longstanding principles of Fourth Amendment. Probable cause and particularity serve different purposes. First, the magistrate's scrutiny is intended to eliminate altogether searches not based on probable cause. The second distinct objective is that those searches deemed necessary should be limited, as limited as possible. Here, the specific evil is the, quote, general warrant, end quote, abhorred by colonists. And the problem is not that of intrusion per se, but of a general exploratory rummaging in a person's belongings. The warrant accomplishes this second objective by requiring a particular description of things to be seized. This all makes sense to me. Yeah. And they're just providing more supporting case law. In the words of the Supreme Court, that is like saying a ride on horseback is materially indistinguishable from a flight to the moon. Modern cell phones as a category implicate privacy concerns far beyond those implicated by the search of a cigarette pack, a wallet, or a purse. A conclusion that inspecting the contents of an arrestee's pockets works no substantial additional intrusion on privacy beyond the arrest itself may make sense as applied to physical items, but any extension of that reasoning to digital data has to rest on its own bottom. This is more, again, supporting case law. Thus, returning to our analogy, the Ohio Supreme Court, Ohio Supreme Court found the warrant failed as to where category and what description of the file sought. As the court noted, the where and what can be named with more specificity based on what is known to law enforcement. In this case, the things to be seized are an exhaustive list of everything that is available in Apple accounts. Law enforcement was certainly capable of greater specificity, but instead gave itself an overbroad mandate permitting it complete access to everything from Mr. Kohberger's Apple accounts. And there's more examples. I mean, I agree. It was definitely looked like it was an overbroad search. And then here's the conclusion. Yup. I missed this comment. I'm not sure what that's in relation to, but if I said something was special, I was probably saying Idaho because Idaho has, they've put time and time again, Idaho has specific rules as it pertains to search and seizure that set it apart from other states and the federal government, in case that's what that's in reference to, that they have a particularly higher standard and interest in protecting people's personal privacy as it regards to, or as it relates to searches. So here's the thing, guys. We're gonna have to split this up into more than one stream because I have to go teach a violin lesson, or more than one. I have a couple lessons. So what I will do is, because we just finished this document, we will pick up next time with the arrest warrant. Oh boy, motion to suppress and memorandum in support of the arrest warrant. That's where we will pick up next time. So what I will do is, I had initially scheduled a Casey Anthony stream for tonight. I will move that. Till tomorrow. And tonight, when I get finished teaching, we will pick up where we left off and hopefully be able to cover the rest of these filings that have come in, of which there's how many more? Quite a few more. But this is very interesting. This is very interesting. It'll be really, I'm really curious what's going to come. Like, we're going to get responses from the state. Like I said, we will hear something from the judge at some point. Really interesting. 1, 2, 3, 4, 5, 6, 7. So what we have coming up next, again, the arrest warrant is next. And then we have the ATT warrant, cell phone data, Google, pen trap trace device, at which point I'll learn what the hell that is. Person in Idaho, person in Pennsylvania, the white Hyundai, oh boy, and 119 Lamsden statements. And then we have an order denying the motion for leave. So we will cover all of those tonight. So, it is very interesting. Yes. So, wow. I just to reiterate for my own sake too, I'm going to keep my eye out for what I have still not yet seen, which is the thing about the trash being on private property specifically. Like, we saw the gated community, we saw there was an ordinance, but they didn't come right out and say that trash was off limits. So it'll be interesting to see what else comes of that, right? Like, maybe there's some reason it wasn't off limits. But according to what we saw on that second site we went to with the house stuff, it says it's a private road. So yeah, again, unless it was a fluke where they, he putting the trash in the neighbor's garbage can, and then that was where they got the DNA for his dad, and that particular place was not private road. That would be the only workaround I could think of, unless there's some other exception. But I mean, that's a problem, right? If all that pans out like that was private, I don't know. But I feel like that would have been like the first thing the defense would have tackled, right? Because that seems like such an obvious, like, again, for everything is fruit of the poisonous tree from that. And there's other ways that they have been trying to fight the IGG. Again, if we go back to the whole thing about the IGG being so important, right? And everything is a result of IGG, which is true. There's been all these other ways that they've tried to tackle the IGG that haven't panned out. But to me, the most obvious is, if the IGG, again, was taken from the trash was on private property, that's completely different story. That's a completely different story than trying to attack the science behind it, right? Or like, the databases, or, the other arguments they had made early on in regards to the IGG were more specific to the IGG itself. And is it tested? And is it is it considered a valid science and whatnot, right? And, that wasn't going to go anywhere. But again, if the IGG came from a sample that was in private trash, that's a whole different story. So yes. Okay. But y'all, thanks for being here. Hopefully you guys will be able to join me for part 2, depending on how this goes. There might be a part 3. We will just sort of see. But as always, I will get timestamps too. So if you guys are on replay crew, you'll be able to sort of see what's going on and skip to certain parts if you don't want to watch the whole live stream, etc. But other than that, y'all are awesome. Thanks for being here and for all of y'all's help too, right? Reminding me of things that happened a long time ago, and with the addresses and all kinds of stuff. Thanks for y'all's participation as we delve through all of these documents. Definitely was not expecting this. I was not expecting this. Were you guys? Let me know in the chat or in the comments if you're on replay crew, if you guys saw this coming. I mean, I don't know how one would see it coming, but like, still, even with that, it's like, I'm shocked. Again, because it just seems like we are pushing forward towards trial. Anyway, it's just, wow. And the other thing too, just as a side note, if they're spending so much, the defense team is spending so much time preparing all these motions, you know what that means? That they're doing less time is preparing for trial, right? Like witnesses. And I mean, you know, they're still dealing with all this stuff. Meanwhile, the state is probably actually preparing for the trial, which is an interesting thought as well. Yeah, I mean, so there's been like whiffs of these issues, specifically from there hadn't been court documentation of it, right? And so for me, that's the difference, I guess. Like, I mean, there's rumors or speculation. To me, this is really different because we have it in writing, and it's a, you know, it's a legal document. It's just it's very different, you know. Even though we don't have everything because some of it's under seal, it is supporting. It's supporting these things that we'd heard whiffs of or whatever. Now we actually have like substantial supporting evidence, even though we don't have all of it yet. It just you know, like I said, for me, I had heard just like whiffs and rumors or whatever, but that's true with every case. And, you know, oftentimes does that mean anything, right? This is just very different to see it in writing, in all of these, you know, filings. So yeah. Okie dokie. Y'all are awesome. And hopefully see y'all tonight for part 2. And we will sally forth and see y'all then.